Okay, good morning, everyone. Welcome back to arbitration. The last 2 weeks we discussed key arbitration concepts, by which I meant legal concepts you need to know in order to understand arbitration, how it works and how it is intellectually constructed. This week we continue on a somewhat similar trajectory, in the sense that we deal with core things you need to know in order to understand how arbitration works and what it really is. But it's different from what we did the last 2 weeks in the sense that the concepts we are going to discuss today are nothing new. They're not specific to arbitration. They just play out differently in arbitration. So no conceptual novelty, no notional novelty at all today. It will be things, well, I'm going to show you. We're going to talk about things like confidentiality, how confidential arbitration really is. The notion of confidentiality, obviously, you already know. How procedurally flexible it is, how much it can be adapted to the needs of the parties, what the parties can do with it, how they can tailor it to their own needs. Finality, how final is arbitration? Once you get an arbitral award, is it the end of the story? How likely is it that it is the end of the story? Compared to when you get a court judgment. You go to court, you get a court judgment. Is that the end of the story? Well, perhaps not. There may be appeals, and then you'll have to enforce it. These are the sort of questions we'll discuss here. Then we'll turn to recognition and enforcement, which as the name suggests, deals with the recognizing the validity of an arbitral award abroad, typically. If you have an award rendered by an arbitral tribunal with seat in Geneva, for instance, and you want to recognize that arbitral award in Brazil, for instance, can you do that? What it means to recognize it, it means to give it legal validity there. I'll expand on that later on. Can you do that? Why would you do that? And on what are the legal texts that you would need that tell you what the conditions are? Likewise, if you want to enforce it against the assets of the losing party, if the losing party doesn't want to pay up, what can you do in order to have that award recognized abroad? That's what we're going to do today. And we'll end with an in-class quiz as we did last week with some exam-type questions. I repeat, the questions we have here in class are more vague, they're more meant for discussion, to trigger doubt, to make you think, as opposed to test your knowledge. Those in the exam will be more straightforward. Okay, confidentiality. I'm going to talk about 4 main aspects of confidentiality. I'm going to talk about the importance. Why is confidentiality important for arbitration? Then I'll mention the fact that arbitration is usually described as something confidential. Is that true? Empirically, yes. Is that true as a matter of concept? Well, no. Arbitration does not have to be confidential in order to be arbitration. There's nothing inherent about arbitration being confidential. Then I'll turn about, confidentiality of what? Which part of an arbitration is, when we say that arbitration is confidential, what do we mean exactly? Which part of an arbitration is confidential? Who is bound by a duty of confidentiality of the different actors involved in an arbitration? Why can't you attend an arbitration hearing? I was asked repeatedly, I'm asked every year, can we attend an arbitration hearing? The answer is, I'm afraid not, except if everyone involved agrees, which essentially never happens. Why is that the case? And then we'll go through the typical rules, how the rules of arbitration institutions explain, how they lay out, how they define this notion of confidentiality. Okay. So the importance of confidentiality for arbitration, well, confidentiality is in every survey of arbitration users. My colleagues at Queen Mary, University of London, they have a big arbitration center, one of the oldest in Europe. We just celebrated the 40th anniversary of that big center, Queen Mary, University of London. If you want to study arbitration, it's a good place to go later on to London. And they have been doing regularly surveys of arbitration users. So they ask people who choose arbitration in their contracts, why do you do that? What's, in your view, the advantage of arbitration? So looking at the selling points of arbitration from the perspective of those who buy these legal services, not from what it should be in theory. And people respond systematically, we go to arbitration because it is confidential. We put an arbitration clause in our contract because it is confidential. That's one of the things which comes up the most often. It's not the only one, but it comes up very often. By the same token, arbitration institutions, when they advertise arbitration institutions are in the business of selling arbitration. They're trying to make money with arbitration. They're trying to have as many parties use as much arbitration as often as possible. When they advertise, when they make publicity for arbitration, they systematically put forward the same idea: arbitration is confidential, it's great for you, the parties. Why is that important for the parties? Why is it appealing to the parties? Why does this convince parties to go to arbitration? Well, it protects your reputation. If you're a party, this protects your reputation. If you are, let's imagine you are Nestlé selling 20 tons of dairy products to Danone in France, and these 20 tons get stuck somewhere, and when they arrive, the products have turned sour, they're no longer good for consumption. Well, you don't want the entire world to know. What would happen if the entire world knew? Well, your stock valuation would probably go down. You'd lose money. Its bad reputation in itself is important, and it has a direct economic value, reputation. So you may not want, as a party in arbitration, as a business entity, as a business generally speaking, you may not want everyone to know that your company did something incompetent, unsavory in another way, or that the financial situation of the company is actually quite bad. It may be that if you go to court, that you have done nothing wrong, but you have to submit to the court documents which show the financial state of your company, which, if it is bad, again affects stock valuation. It affects your capacity to obtain loans from banks, and in a nutshell, it's bad for business. This has led arbitration to have a reputation in certain circles, certainly in the circles of journalists, that arbitration has a reputation for being a thing of shadows, a shady business, where the less savory parts of the world's deals take place. Maybe a bit exaggerated, but this notion of secrecy, in particular in our current society in which we live, in which transparency seems to be so important, arbitration stands out a bit as the kind of justice about which we actually don't know much, and we cannot attend the hearings. The awards are confidential. It doesn't smell good to many people. It also feeds into this notion of confidentiality, also feeds into the notion that arbitration lives in a world of its own. That social, professional, ethical norms, they aren't quite the same as they are for the rest of society. They aren't quite the same as for the rest of lawyers. They aren't quite the same as what you would find in court. This has led to long and complicated theories about arbitration being a legal system of its own, separate from any national legal system, separate from the international of the legal system of public international law, that it exists as something out there which is not really democratic, cut off from the control of states, and which is appealing to some people who like secrecy and feels uncomfortable to other people. And lastly, in the same line, there is a sense in arbitration, around arbitration, not always, but definitely sometimes, that the richest 10% in society, or only the big corporations, they live under a different set of rules with their own courts, arbitration, their own procedures, arbitration again, and their own sources of legitimacy. That's how arbitration is often perceived. Again, I think I mentioned this in the past, I'm contacted fairly regularly by journalists who ask me questions about what is this thing, arbitration? Is this a justice of the shadows? And I cannot really answer, well, clearly not, it's perfectly legitimate. There is this problem of protecting the reputation of the parties is not entirely innocent, let's put it this way. Okay, enough about values and worldviews. Let's get back to more straightforwardly legal questions. So now that we know that confidentiality is an important feature of arbitration, we can turn to ask whether arbitration actually is confidential, rather how confidential it is and why this is so. I try to explain that arbitration is not inherently confidential, but it is confidential by default. It's not the same thing. Something which is inherently confidential means that it has to be confidential in order to be the thing it is. When it is confidential by default, it means that it typically is confidential, but the parties can agree to not make it confidential. So if it would not be correct to say arbitration is confidential, full stop. Confidentiality does not define arbitration. Public arbitration is definitely possible. It's rare. You find the overall movement is towards publicness or publicity. Well, that's a bad word. Publicness is probably the better word, towards publicness in arbitration, to a large extent to push back against this notion of it being a shadowy business, which I described a few minutes ago. The World Bank for investment arbitrations is pushing very strongly in favor of publicness, of making hearings and other aspects of an arbitration public. The ICC in Paris is pushing fairly strongly the parties to agree to publish as many aspects of an arbitration as possible. The overall movement is towards less confidentiality. Probably as a way to say, to acknowledge that society may want to have a say, or at least to have a look at the kind of justice, kinds of justice that take place within society, that we should be aware of this sort of justice decisions rendered around us. So arbitration is progressively becoming more public. Investment arbitrations, about which we'll talk later on in the semester, now increasingly even the hearings are sometimes broadcast on the internet. You can follow live the hearings on the internet. There was one hearing once where in front of several hundred people who were in a room who could attend. These were particularly sensitive arbitrations, but so the trend is towards publicness. That being said, for the time being, arbitration typically is still confidential. So if you say arbitration is confidential, as it's not technically correct, but it is a good understanding in just 4 words of how arbitration usually works. It is typically confidential. How does that happen? Either the parties make arbitration confidential by agreement. They can always do that. If the parties want to keep an arbitration confidential, they can do that. If the World Bank pushes back against that, the parties have the final word. If the ICC pushes for more publication of more aspects of an arbitration, the parties have the final word. And more often than not, the parties think that it is in their interests, to a large extent because of the reputation matter I mentioned, that it should be kept confidential. Yes, please.
Is the arbitration decision is subject to review by the Federal?
Yes.
Is that decision public?
Good point. So the question for those in the back or those here listening to this online is when an arbitral award is challenged before the courts of annulment in Switzerland before the Swiss Federal Tribunal, then that award, of course, becomes part of the case and is no longer confidential. Yes, there are limitations to confidentiality, to which I'll turn later on. Yes. The awards, and only the awards, not other aspects of an arbitration. We haven't gone yet into the dimensions of confidentiality, which aspects of an arbitration are actually confidential. My point here is to say what makes an arbitration confidential? The parties' agreement, and that the law allows the parties to make arbitration confidential. How do they do that? Well, the parties can make an arbitration confidential by express agreements. Either there is a duty of confidentiality in the arbitration agreement itself. All disputes arising all disputes arising out of this contract shall be resolved by arbitration in a confidential manner under the rules of XOI. That's one possibility. Second possibility, much more frequent in practice, All disputes arising out of this contract shall be decided by arbitration under the rules of the ICC. Okay, what do the rules of the ICC say? The rules of the ICC say arbitrations are confidential. That's what is on the slide, through institutional rules. So the parties agree to institutional rules, and these institutional rules are incorporated into the arbitration contract, and that makes the arbitration confidential. Or implicitly. What does that mean? The parties can implicitly agree to make an arbitration confidential. Well, what does that mean? It means that most courts, the vast majority of courts around the world, consider that the very agreements to make arbitration, the very agreement to go to arbitration is interpreted as including the want of the parties to make an arbitration confidential. It is implicitly read into the agreement to go to arbitration that it shall be confidential. So most courts would consider that an arbitration agreement implies a general duty of confidentiality. We still don't know what aspects of an arbitration are confidential, but a general duty of confidentiality. So if you ever advise a client, and if the client says, should we put an arbitration clause in the contract, and you say, well, yes, one of the consequences will be almost certainly that the arbitration is going to be confidential. Do you want that? Perhaps. Do you not want that? Perhaps as well. Remember, I hope I mentioned it. If I didn't mention it, just raise your hand and tell me to elaborate. The employment arbitrations at Google about the sexual harassment cases were confidential because of that. And the employees would largely have preferred these arbitrations to be not confidential, to be public. So if an employee who can negotiate a contract, let's assume that, comes to you and says, say, a CEO, important person who can negotiate an employment contract, comes to you and says, there's an arbitration clause in my contract. Is this good for me or not? Probably your answer will be, not necessarily. You may want to opt out of confidentiality in the arbitration agreement. Depends on the needs of the case, of your clients. Okay. So when we say arbitration is confidential, what exactly is confidential? What are the dimensions of confidentiality? Which aspects of an arbitration are confidential? Well, one way to answer that question, it's a bit a cheap answer, is, well, let's look at the institutional rules, and which we're going to discuss later on. If the institutional rules say something about that, well, that's clear. The institutional rules will tell you whether the existence of the arbitration is confidential, whether the stage at which it is confidential, whether the parties, the identity of the parties is confidential, whether the hearings are confidential, whether the documents submitted to an arbitration are confidential, whether the award is confidential, and if the experts appearing in an arbitration are bound by a duty of confidentiality. If I appear as a witness, as a legal witness, for instance, on a point of law in an arbitration, can I tell you about it? We'll see. If I'm counsel, can I brag about the fact that I'm representing party X in an arbitration, and so on and so forth. We'll elaborate on this. The point simply is to say, first port of call, first place you look at, institutional rules. Typically, they would be pretty clear about that. If the institutional rules are silent, or if you go to ad hoc arbitration, which, as you'll remember, is arbitration without an institution. If you don't have an institution, you don't have institutional rules. Okay? So you don't have rules which explain whether an arbitration is, which don't explain in detail which aspects of an arbitration are confidential. What do we do then? We have to distinguish between, on the one hand, this is based on the practice of courts around the world dealing with questions relating to confidentiality when there are no clear institutional rules on the matter. We have to distinguish between the arbitration hearings and of the meetings involved in an arbitration, the existence of the proceedings, the material disclosed during an arbitration, and the arbitral award itself. Let me take them in turn. Let's start with the arbitration hearings and other arbitration meetings. Again, the premise is the rules are silent or are unclear, or there are no rules at all on this, no explicit rules on this. The situation is still pretty clear. All or virtually all jurisdictions around the world would find arbitration hearings and meetings not to be public affairs. They are confidential, cannot be attended by anyone unless the parties agree. Which was my point earlier, the request I received sometimes by some of you, can we attend an arbitration hearing if you can convince both parties to an arbitration to let you in? This almost never happens. In large investment arbitrations, sometimes, but for normal arbitrations, almost never. Not great for pedagogy, but that's how it is. It's not their priority exactly. So this is pretty clear. Existence of the proceedings. Can you start an arbitration? Again, a client comes to see you, says, I have this arbitration clause, and so I don't have a choice, let's go to arbitration. Can I say that openly? Can I say, we just sued party X in an arbitration? Does the existence of the proceedings, is that confidential? It's somewhat uncertain. The transnational or general answer, we haven't gone yet into which law applies to that, which is a complicated question, but the general answer, so I'm going far beyond Swiss law. I repeat, Swiss law is not necessarily very important for arbitrations, including arbitrations seated in Switzerland. For a number of reasons, or it's not the only law that is important. The transnational general answer is, it is quite uncertain. It is not necessarily a breach of an implied duty of confidentiality, because I recall in the situation we're discussing, there are no explicit rules. It is not an implied duty of confidentiality to reveal the existence of arbitration proceedings. So if your client asks you, can we put on our website, can we talk to the press about the arbitration we have started against someone, or vice versa, someone has started an arbitration against us, and we think this is a grave injustice, can I talk about this to the press? What it depends on a bit is this part here. When the information that is shared with the public is biased or slanted, then it is more likely to be a breach of confidentiality. If you distort reality a bit about the arbitration, then that in itself is a breach of the notion of confidentiality. It's not simply that you are lying or misrepresenting reality, it is that this becomes a breach of confidentiality. So the more neutral the publicized description of the dispute is, the more likely it is not to be a breach of an implied duty of confidentiality. So far, yes?
Wouldn't revealing the existence of an arbitration publicly affect the reputation of the parties? So
Yes.
What is not mentioned?
It is, some countries have considered that that simply revealing the fact that there is an arbitration is not damaging enough on the other party to be completely prohibited. I understand from a policy perspective, we might think it should be kept completely out of the public eye. There's this tension, which I mentioned earlier on, this social tension between we should know who's suing whom, we should know what kind of justice is happening, we should know when a company is in difficulty. And on the other hand, the right to secrecy of companies. It's a political choice. But I take your point of view. It's fair enough. Let's put it differently. The reputation of the parties is not the only thing that matters. It's one thing that matters, and it should be put in a balance against the rights of the public to know what is going on. Okay. There may be situations where you have to disclose it. There may be rules of the stock exchange which create an obligation for you to reveal all legal disputes in which you are involved. I'm not good enough at the rules of stock exchanges. I believe that in the London Stock Exchange, so if you are listed on the London Stock Exchange, and you have a legal dispute against you, if proceedings have started against you, you have to disclose it because it affects the value of your company. So in this case, it's partly an answer to your question. Again, it is in this case the law or the stock exchange, the rules of the stock exchange, which say the reputation of the parties should not be protected to the disadvantage of the shareholders. The shareholders should know what is happening. You might say this is a strange situation because the value of the shares goes down if the reputation is affected, but the shareholders have to know whether there's a threat that the company is going to go bankrupt and sell their shares. It may go bankrupt if it's being sued in a big arbitration. It's a matter of balancing interests again. You may have to provide information to auditors. Certain publicly traded companies need to be audited from time to time. In these situations, you may have to disclose that kind of information. If you have legal insurance for certain aspects, if you have a form of insurance, you may have to disclose to the insurer that that the legal dispute has started now. So these are exceptions to the overall implied duty of confidentiality. And usually institutional rules provide for that. They allow for that. They say an arbitration is confidential except if you have a legal duty or contractual duty, a pre-existing contractual duty to reveal information about the existence of the proceedings. Okay. Now we turn to the confidentiality of material disclosed during an arbitration. So, for instance, in an arbitration, you have to submit, you'll submit exhibits, you'll submit witness affidavits, you'll submit copies of accounts, things like that, to show the damage you've suffered, to show the correspondence between different parties, to explain what happened. You'll build your case based on exhibits relating to factual exhibits explaining the facts. These are clearly confidential. Even if you have a duty to report the case to the stock exchange, you cannot reveal that. You cannot share these documents with the public. A bit more concretely, what does that mean? I need to make a subdivision here. Quite obviously, the transcript of the hearings, who said what during arbitration, they are confidential. Notes of evidence, as I mentioned, exhibits, facts, and so on and so forth, are confidential. Your pleadings, the pleadings of the two parties, are clearly confidential. Any other written submissions, any witness statements, all of that is confidential. The idea here is that if the hearings are confidential, but you could reveal these things, the transcripts of the hearings, then you would defeat the purpose of making the hearing confidential. Now, some parties have used that to say there are documents in the public which the press hasn't seen yet, and they are bad for our reputation. So we're going to take them, start an arbitration in order to submit these documents in an arbitration, and then they are confidential. So we make them disappear from the public eye. You cannot do that. The example here is about historical documents, but documents which were not created for the purpose of the arbitration do not become confidential by the fact that you submit them in an arbitration. Okay? You cannot make documents which pre-existed the arbitration confidential by submitting them to arbitration or in an arbitration. Okay? If there's a damaging report about me out there, about how terribly professor I am, I cannot take that report, start an arbitration against one of you, assuming you agree, and I submit the report and then say, oh, that document can now no longer be shared by anyone. And the student organization which had put out that terrible note about me, I'm going to sue it for breach of confidentiality if they maintain that as an open document. Fairly commonsensical, I suppose. Likewise, this more often happens with historical documents about maybe treaties between countries or historical documents about what land belonged to whom at what point in time and so on and so forth. All of that cannot be made confidential by submitting it to arbitration. Okay. So this is the, if you will, the theory or the general principles. What do the rules say? This is the rule, or one of the rules on confidentiality. There's several in the LCA, the London Court of International Arbitration. I read this out to you. The parties undertake as a general principle to keep confidential all awards in the arbitration, together with all material in the arbitration created for the purpose of the arbitration, and all other documents produced by another party in the proceedings not otherwise in the public domain. Note, it's the parties undertake. This provision here, this rule, does not bind the arbitrators, the experts, and anyone else involved in an arbitration, only the parties. Which would mean, if this were the only rule, that the arbitrators could say, oh, I'm now an arbitrator in a case between Nestle and Danone, when Nestle and Danone themselves are not allowed to share much of anything about that case. In reality, arbitrators are bound by confidentiality as well, but it's important to read what the clause exactly says. Another rule of the LCIA, which now binds the LCA itself. So the institution itself commits to confidentiality by saying we will not publish any award or any part of an award without the prior written consent of all parties and of the arbitral tribunal. That most, or if not all, arbitration institutions have that rule. As I mentioned earlier on, the ICC also has that rule, but is trying to push the parties and the arbitral tribunal to agree to give their written consent to the publication of the award, possibly in anonymized fashion, without the names of the parties. To say, this is the sort of, these are the sort of decisions that are rendered by ICC arbitral tribunals. Look at them, they're great, no. It's a way of advertising their work, advertising the work of ICC arbitral tribunals. A couple more are the Swiss rules. Again, unless, I'll read it out to you, unless the parties expressly agree in writing to the contrary, the parties undertake to keep confidential all awards and orders, as well as all materials submitted to another party in the framework of the arbitral proceedings, not already in the public domain. This undertaking also applies to the arbitrators of the arbitral tribunal, the tribunal-appointed experts, the secretary of the arbitral tribunal, and all the other people related to, involved with the Swiss rules with this particular case. Yes, please. Very good question. I repeat the question. What are the consequences if a duty of confidentiality is breached? What are the legal consequences, and where do you go? Do you go to arbitration to have that resolved, or have sanction inflicted on the other party, or do you go to court? You can do both for two different reasons. You can go to court if it has created, if you suffered a damage, and you it's a breach of a contract, and you suffered damage, and you sue the party. Fair enough. You can also go, which is what happens more often in practice, you go to the arbitral tribunal and say the other party breached the confidentiality agreement. You have to punish the other party. How is that punishment going to unfold? What form is it going to take? It's going to be reflected in the allocation of costs, potentially in the awards. In the award, that's debatable, but in the allocation of costs, who bears the costs of the arbitration, who bears the costs of the lawyers on both sides, that definitely plays a role. You systematically breach confidentiality in this arbitration. I'm going to allocate all of the costs to you because your behavior in the arbitration was not acceptable, so you have to bear the costs. This is what would happen. Arbitrators typically really don't like that if you breach a confidentiality agreement. So you also anger arbitrators, which is probably going to influence their decision making. It's a very good question. Okay. A couple more. How many more do we have? 3 more. Okay. Unless another, this is SIAC, Singapore International Arbitration Center, so this is Singapore. Unless otherwise agreed by the parties, a party and any arbitrator, including any emergency arbitrator, and any person appointed by the tribunal, including any administrative secretary and any expert. Large list of parties bound by arbitration shall at all times treat all matters relating to the proceedings and the award as confidential. That's a very broad notion or clause, confidentiality clause. A long list of different actors involved in an arbitration, which are all bound by confidentiality, and that confidentiality extends to, I repeat, I read out again, all matters relating to the proceedings and the award. Sanctions, partly to your question, this is again the Singapore rules. The tribunal has the power to take appropriate measures, including issuing an order or award for sanctions or costs. So even award for sanctions under these rules are possible. So not only the allocation of costs, but a specific award of sanctions. That may be the validity of an award on sanctions can be debated, but on costs is not debatable, and this will typically happen. Last one, Hong Kong International Arbitration Center. Unless otherwise agreed by the parties, no party may publish, disclose, or communicate any information relating to A, the arbitration under the arbitration agreements. You can't talk about the existence of the arbitration. B, an award made in the arbitration. It's not the only clause in the Hong Kong rules. Section 2, subsection 2, the provisions of Article 42.1 also apply to the arbitral tribunal, any emergency arbitrator, expert witness, secretary of the arbitral tribunal, and the Hong Kong International Arbitration Center itself, that is to say, the arbitration institution. Okay, so what we've seen is different dimensions of confidentiality in the sense of different aspects of an arbitration being confidential. We have seen that they're not necessarily always all confidential, it depends on the rules, and which actors which involved in arbitration are bound by confidentiality. It is fair to say that a rule like this one is fairly common in practice, that this ends up being the solution, that all matters relating to the proceedings and the award are confidential for all the actors involved. Still, the legal constraints of the stock exchange and so on and so forth overrides these clauses here. So if the stock exchange forces you, creates an obligation for you to reveal information about the arbitration, you cannot hide behind rules like this one to say, sorry, the arbitration rules have created a duty of confidentiality for me. The hierarchy between these types of rules, rules of, if you will, public interest, rules of the stock exchange, overrides these rules of private interest. That's how they are interpreted. Okay. Procedural flexibility. How much can you adapt an arbitration to your needs? If you are thinking about, to give you a simple example, I had a colleague a long time ago who came to see me to say, we are creating a spin-off of the university. He was a computer scientist. We are creating a spin-off, an independent company. And we are working with people in his case it was in Israel, and we want to work with people there. It was 20 years ago. And we want to work with people there, and we'd like to go to arbitration. But it's a particular company who wants to have a particular form of arbitration. What exactly can we do? What is our flexibility? Is arbitration just this one thing which we opt into or not? Or can we, once we opt into it, can we tailor it, can we adapt it to our specific needs? And the answer was, well, you can do almost whatever you want with an arbitration as long as the two parties agree. I'll discuss three main points about this. The principle of flexibility, what this idea is, where it comes from. I'll give a few examples, and I'll say a few words about the limits of this procedural flexibility. And there the answer will be almost none. As I said, you can almost adapt arbitration to whatever your preferences are as long as the two parties agree. So let's start with the principle of procedural flexibility. What's the key idea here? The key idea is that the parties control the proceedings. Sometimes people say a bit jokingly that arbitration is the plaything of the parties, to which Serious people often respond, well, play things, this is not a game, but the idea clearly is there. It's something controlled by the parties, not by the arbitrators, not by the arbitration institution. That being said, there may be tensions between what the parties want, what the arbitrators want, what the arbitration institution wants, and what the law says. But by and large, the central actors are the parties who can do with an arbitration more or less whatever they want. The parties may well, let me skip that. That's introducing a complication. Let's skip at the general principle. So the idea, again, is if we go back historically to where arbitration came from, to the first class of this course, remember that arbitration is there for the parties. Remember that arbitration started out as two traders calling on a third trader to resolve the dispute between them so that it is best for the two parties. If arbitration is there for the parties, if it is an evolution of the idea that two traders turn to a third trader to make a decision for them, why not let them do it in whatever way they can? Since you're opting out of public justice, why not let them do it in whatever way they want? As long as the parties agree, as long as one party doesn't force another into doing something they don't want. So, again, shaping the procedure is done by both parties together. So you can't unilaterally, as a party, say, this is what I want from the arbitration. This is part of a negotiation. This is what I want in an arbitration. What do you want in arbitration? Let's try to negotiate a good arbitration clause or particular rules for our industry. Which also implies that if you want to have a particular arbitration institute, a particular way in which you set up the arbitration, a particular procedure. For instance, the Court of Arbitration for Sport during the Olympic Games, a very specific procedure, renders decisions within 24 hours. If you want something like that, it is definitely possible. You have to agree at the time of negotiating the arbitration agreement, or when you set up an institution, the rules of the institution. Don't wait for the dispute to come up, and then try to agree on something. If your client says, a client comes to you and says, should I have an arbitration clause in my contract? But do know that if there is an arbitration, I really want this to go quickly. I was promised that this would go quickly in arbitration, so I want something resolved within 3 months. You should not tell your client, oh, fine, let's go to arbitration, and if there is a case, if we have a dispute, if we do go to arbitration, then we'll make sure it takes place within 3 months. That will not work. It will not work because once you have a dispute, there's a general state of hostility, and the standard practice in arbitration, once an arbitration has started, is to say no to everything the other party suggests. I'm slightly exaggerating, but that's the general spirit. Once there is a state of hostility, it becomes almost, which is a way to say when an arbitration has started, it becomes almost impossible to negotiate mostly anything in an arbitration. So if you want a particular procedure, you can have that, negotiate it at the time of entering into the arbitration agreement. So if you're creating a student association and you want to have an arbitration clause for disputes between members of the student association, why not? I hope it never comes to that, but if you want to do something like that, then don't simply put an arbitration clause in the statutes or in whatever contract you have, but do negotiate what exactly the arbitration would be at that stage. Don't wait for any potential dispute to come up. I hope none of you will sue anyone else in an arbitration. But okay, examples of the usual aspects of an arbitration that parties play with, that they may want to adapt to their particular needs. The one I mentioned early on, they may want to make some aspects of an arbitration non-confidential, that is to say public. They may want to make the award public, including potentially the names of the parties. For one party to say, we won this arbitration and we want the world to know how great our case was, and the losing party may want to show the entire world how unfair the arbitration was and how they lost to what they think as incompetent arbitrators. In investment arbitrations, this sometimes happens, that the states say, let's make this award public, let's show the world how problematic investment arbitration is. Read the award, read what these people do to us. We, poor country, read at what these people, and indirectly the World Bank, what these people are doing to us. So both parties may want to make an award public. Okay, beyond that, parties may want to make a procedure more extensive, to add more witnesses. They may ask the arbitrators to put on their rubber boots and come with them to visit the site of a construction project which collapsed. And you do see sometimes arbitrators dressed in fancily in their rubber boots walking through the mud to look at a construction site where some damage occurred. If the two parties ask the arbitrators to do this, it is very difficult for the arbitrators to do, thank you, but no, I won't do that. The arbitrators most likely will have to comply with what the two parties together ask the arbitrators to do. And if sometimes it can happen that the two parties say we need 3 weeks of hearings, when the arbitrators say, well, 2 days would really be enough, and then things become a bit complicated if the arbitrators can push back and say, no, come on, 3 days, 2 days is really enough, we don't need 3 weeks. By and large, if the two parties really insist, it's difficult to go against the will of the parties. That's a way to make the procedure more extensive, that lasts for longer. Which, as to be cynical, once again, you'll notice, is in the interest of the lawyers, not necessarily in the interest of the parties, but clearly in the interest of the lawyers. The lawyers will typically push to say, we need to hear more witnesses, we need to find more documents, we need to go for more document production, asking the other party to reveal more documents. We need more of that because we can bill by the hour. The parties, if it's good for the parties, it's paying a lot of money to get closer to judicial, respectively arbitral truth. But that depends really on the case at hand. Okay, time for a break, and we'll continue with that after the break. Thank you very much.
When each
Okay, let's get back to it, please. Okay, we are back here live. End of the advertisements. Okay, so one possibility that I mentioned is to make the procedure more extensive, to add more aspects, to hear more witnesses, to do site visits, and so on and so forth, because the parties believe that this will be good to get closer to a decision which will make them prevail. Okay, you want to fight more. And so one possibility, as I mentioned, is site visits, a bit more evidence. Another is, briefly, I'd like to talk about discovery. Discovery is a US notion. It's a notion which comes from American civil procedure law. You have something somewhat equivalent in English court procedures, where it is called document production. The idea of document production and discovery, which probably will be shocking to civil law lawyers, is that you may be forced to reveal, to submit to the arbitral tribunal documents which you have which are damaging to yourself. So if I start an arbitration against you, I'm going to, and discovery, we agreed to have discovery, if we agree to have document production, I will ask you during the arbitration to share with the arbitral tribunal and with me all the emails that you sent within your company to one another to discuss our case. All the transcripts of meetings, all the memos you have in your possession, or which I think you have in your possession, I'll force you to reveal them. That's discovery. What does that lead to in practice? It leads in practice to, so if I'm a big company, I'm Nestle again, you're Danone, you ask me to reveal all the documents in my production, what am I going to do? I'm going to send you 20 gigabytes of documents to drown you in documents. That what you're really looking for is there, but it's buried somewhere in the 20 gigabytes of documents. Which means what? Which means that you'll have to go through the 20 gigabytes of documents, which means that this is going to take a long time and is going to cost a lot of money, which is one of the things that has made arbitration so expansive in the last 20 years. Which is also the one place where artificial intelligence is developing most quickly, to sift through 20 gigabytes of documents to find the one memo in which your surveyor wrote to their boss to say, well, yes, there's a crack in the dam. Indeed, we noticed that, and it's our fault. To find that document is where we would use artificial intelligence, because of discovery. But you can exclude discovery. You don't need to agree to discovery. At the time of agreeing to go to arbitration, you would agree to that, or it's part of the arbitration rules. Okay. More rounds of submissions, post-hearing briefs. When you have, quite often, typically in arbitration, you have 2 rounds of pleadings, of written submissions. It does happen that the parties say, oh, we want a third and we want a fourth. And because perhaps after the second round of pleadings, of submissions, there are the witness exhibits. You see what the other party has in terms of facts, and you say, oh, that leads me to new arguments, so we'd like to have another round, and if we get a third round, then the other party gets a third round as well, and this can keep going. Quite often, during the hearings, the oral hearings, the parties would say, a new point came up during these oral hearings. We'd like to take position on that. We'd like to submit pleadings on that. We'd like to submit written statements on that. So we want to have what is called post-hearing briefs, brief submissions after the hearing. And all of that, again, tends to make arbitrations longer and longer and longer. And when I say this is in the interest of lawyers, and that's why they tend to increase, and that's not in the interest of the parties, I'm not the only one who says that. A famous arbitrator, Philip Sands, you may know Philip Sands, he's written a number of great non-fiction books, East-West Street. If you like international law, read East-West Street by Philip Sands. It's a fantastic book. It's meant for the broader public. He's also an arbitrator, and he, for a long while, had kept saying at every conference, all of these developments in arbitration are good for the lawyers. It's bad for the parties. In the long run, it's going to destroy arbitration because arbitration becomes more and more and more expensive. addition of an appeals procedure, you can have two-tier arbitration. An arbitration where you go to arbitration, you're unhappy about the result, you can appeal in the proper sense of the words, that is to say, to raise questions about a wrong application of the law applicable to the merits, the substantive law. You want to appeal that to a higher arbitral tribunal. Remember from last week, or perhaps it wasn't clear, I need to clarify it, you can almost never, except in England and then in some ways in Australia and New Zealand, and perhaps in some situations in Singapore, but essentially you cannot appeal an arbitral award, because the word appeal in English means that you challenge an arbitral awards on a wrong application of the law applicable to the merits. This contract is governed by French law. The arbitrators applied wrongly French law, came therefore to the wrong conclusion, to the wrong outcome. You cannot have an arbitral award annulled on that ground. You cannot appeal an arbitral award on that ground. We've seen that last week. If it isn't clear, do revisit the slides of last week, and if it's still not clear, ask me. What you can do is to introduce an appeals procedure within arbitration. You have two tiers of arbitration. You go to arbitration, the arbitrators applied wrongly French law, you go to a higher arbitral tribunal, 3 new arbitrators, again arbitration, all of the same rules of arbitration apply, and that higher tribunal is going to review the case on its merits. This is possible. Rare, but it happens. Mostly a US affair. JAMS, which is an important arbitration institution in the USA, the American Arbitration Association in New York, they have that possibility, which parties can opt in or not. You can make the procedure going in the other direction less extensive. You can opt for fast-track arbitration. That is also developing in arbitration as a counterpoint in reaction to the increase of costs. That's exaggerated. The vast majority of arbitration institutions, with the notable exception of the London Court of International Arbitration, now have a fast-track arbitration possibility, which applies almost automatically for quote-unquote small cases. With a small case, depends on the institution, can be cases between 2 million or between 10 million, where the stakes are between these figures. In these cases, the arbitration has to unfold more quickly. There can be, for instance, no discovery, there can be a time limit of a year from the beginning of the arbitration to the rendering of the award, or a time limit of 3 months from the hearing to the rendering of the award. There can be a limitation of the length of the pleadings, of the documents, of the memoranda submitted by the parties. They can be limited to 20 pages. So each party can only write the equivalent of 20 pages to prevent submissions of hundreds of pages in length, and so on and so forth. So you can fast-track an arbitration. It's happening ever more frequently to fight the increasing costs and time in arbitration. The most extreme case, I've mentioned it, it's the CAS, which is technically called the CAS Ad Hoc Committee for the Olympics, for the Olympic Games, Court of Arbitration for Sports, specific procedure for the Olympic Games, where decisions are supposed to be taken within 24 hours. Sometimes it's even less, sometimes it's a bit more, but it won't be a week or two. It won't be 2 weeks, because by then the Olympics are over. The idea is that if an athlete is excluded for doping, and the athlete says, no, this was a wrong decision, or if an athlete is excluded for many other reasons, and the athlete says, no, that is wrong, but I want to be reinstated in the competition, and I want to go to the finals, then this has to be done quickly. You can't wait until after the finals, obviously. But legally speaking, this is just a normal arbitration procedure, just very fast track. Limits. So are there limits to the extent to which the parties can shape the procedure? How far can they take this, adapting the arbitration to their needs? Essentially, there is no limit. Of course, the parties can always make it longer, an arbitration procedure, make it more complex, make it longer, make it more expensive. Some arbitration procedures do indeed last for 10 years and cost 10, 15 million in legal fees on both sides. That is definitely possible. The law has nothing to say about that. The somewhat less obvious question is whether the parties can make the arbitration go so fast as to be inconsiderate, that it that it effectively breaches their fundamental due process rights, perhaps even the rights that they would have under a human rights convention. For example, can they waive their right to an independent arbitrator? Can the parties agree, we shall have an arbitration? When the arbitration starts, let's choose my brother as an arbitrator. Can the parties do that? It's clearly a breach of impartiality and of independence. Can they waive their due process rights? Can a party say, I will not be heard in this arbitration? The answer is mostly yes. It is changing. Remember the Uber affair I mentioned over the last weeks, where the parties were asked to give up their right to a lawyer in the procedure. What is happening there is that it would be difficult to have the arbitral awards annulled. What is happening is that the arbitration agreement is disregarded. Whether that is what a number of judges have started to do in Geneva, whether that is actually a legal decision on the part of the judges is not clear. It may be that that they would have to come to the conclusion these arbitration agreements are valid. There are the number of situations for which you can declare an arbitration agreement invalid is limited. So it may well be, that's my opinion, the fact that these decisions of the judges here in Geneva are legally wrong, that they should not prohibit these arbitrations from taking place. So you would find yourself most likely in the legally quote-unquote correct way to look at these cases, most likely the Uber drivers would have to go to arbitration. They would have to travel to Stockholm. I think it is Stockholm. Some arbitrations in maybe Amsterdam, but anyway, they would have to travel pretty far. And they are not allowed to bring a lawyer. And if they lose the arbitration, they cannot have it annulled because they agreed in the arbitration agreement to waive their fundamental rights, including the right to have a lawyer, which is a right under Article 6.1 of the European Convention on Human Rights. What is pretty clear in the case law, and this is partly case law coming down from the European Convention on Human Rights, is that a waiver after the fact is not a problem at all. That is, what I mean by that is you are involved in an arbitration. There is, I appoint as my co-arbitrator, I appoint my brother. You are the other party, you say nothing. Okay, that's, you waive your right after the fact. You should have reacted, you did not. Okay? Or the arbitrator says, during the arbitration, this guy here is not going to have the right to bring any witness, for whatever reason. And I say, okay, and don't react. That is interpreted, considered to be a waiver after the fact. And if you do that, there's no way you're going to get the arbitral award annulled because you waived your right, even if it is a human right. If you waive it after the fact, there's nothing. If you didn't protest during the arbitration, you have validly waived it for any right whatsoever. The waiver before the fact is a bit more questionable, but it is probably unlimited as well. That's the situation where, as I said, we, the two parties, select an arbitrator who is clearly partial, clearly not independent, or in the rule, it even says the arbitrator has to be someone designated by, in a sports arbitration, designated by a sports federation, which is typically the other side, the other party to the athlete. Can you do that? Probably yes. It's not entirely clear, but most likely it is possible. Okay, so you could say, so what? It's the party's problem. What the heck? Why am I talking about these technical distinctions? And the answer to that may, if you think this is shocking or not, if you say, well, if you renounce a right, if you waive a right, that's your problem, or not, the answer, or if you think this is a problem, may depend on whether, sorry to put it so bluntly, whether you're politically left-wing or right-wing. If you're politically right-wing, you would say, each man or each woman to his own or her own, responsible for what they do. If they waived a right, Well, they waived it. It's their responsibility. If you are more left-wing, you would say, what about weak parties? What about someone being tricked by a major corporation? That is unfair, no? That's a typical left-wing argument. I'm not taking position here. You probably noticed where I'm coming from, but that's not relevant. A consumer, for instance, so the typical distinction is in the US, consumer arbitrations are valid. In the EU, they are not. One reason why is that the US is more right-wing and the EU is more left-wing. So the EU says, if you have a dispute between a consumer and a company, that's not acceptable. So we won't recognize the validity of that. If you are in the US, the overall political climate is to say, if you agree to such a clause, if you didn't read the clause, your fault. The same problem comes up with sports arbitrations, where people say, well, if the athletes signed an arbitration clause, well, it's their problem. If they're then stuck with arbitration and they don't like the arbitration, their problem. Other people say, no one should be forced to enter into an arbitration agreement if they want to go to the Olympics, if they want to be pro athletes, if they want to be part of a sports federation. Likewise, with these due process breaches we've seen here with the waivers of certain fundamental rights. The idea really is, how much should people be protected against their own actions? If people agree to a non-independent arbitrator because they were fooled by the other party, should they be protected against that? Right now, the overall understanding in arbitration is each person for their own, and we're not going to intervene in that. As I mentioned, consumer arbitration, that's a bit special, but for most due process infringements, the mentality in arbitration is to say, we have nothing to do here. If the parties agreed, they agreed. Yes?
So the procedure is like unlimited in some way, but it has to be legal. But is it legal for the law of the state or the choice of law by the state?
Okay, so the question is, does the procedure has to be legal? It has to be legal under what law? The law of the seat or the law chosen by the parties? The law chosen by the parties will be the law that governs the substance, the merits, the contract, for instance, which has nothing to do with due process, which has nothing to do with the procedural rights of the parties. So not the law chosen by the parties. It would be the law of the seat. The relevant law for all of these matters of procedure is the law of the seat, always. The procedure has to be legal, yes. My point here was to try to say the parties can make a procedure, quote unquote, illegal if they agree to it. If the parties agree to a procedure which would otherwise be illegal, the law says, fine, your problem. Whether you think that's shocking or not is for you to decide. What I'm telling you is this is what the law says, yes.
Even for the administration of the evidence?
Yeah, even for evidence, if the parties agree that there won't be any witnesses, or that evidence submitted by certain kind of people, or evidence submitted by, sorry to push that far, evidence submitted by women will not be allowed. If the parties agree, that's how they shape the procedure. That is extremely unlikely to lead to an annulment, so long as the parties agree. They have to agree to that. That's the idea of the privatization of justice. You privatize it, you do whatever you want, almost, as long as you agree. I'm being a bit provocative, but on purpose. Where was I? Yeah, we've seen that. Okay, finality. Last point for today. That's the last specificity of arbitration, the last aspect of arbitration I'd like to discuss with you. Actually, there are two more, sorry. So arbitration has greater finality than courts. Arbitral awards are more final than court decisions. What does that mean? The simple understanding is that there are fewer grounds for annulment. The fewer grounds for annulment there are, the more final a decision. In arbitration, there are only very limited grounds on which an arbitral award can be challenged or set aside or annulled. So I think I touched on that last week. I'm going to, with this question of appeals, I'm going to go through it slightly more systematically just now. So here are the typical grounds on which one can challenge an arbitral award. When I say challenge, I mean seek its annulment. seek it to be set aside, seek for it to be quashed, which all mean the exact same thing, but which mean something different than appealing an arbitral award. So you can challenge an arbitral award, seek for it to be annulled, to be made to go away, because the arbitration agreement was invalid. One of the parties did not have legal capacity to enter into it. Or because one of the parties was held at gunpoint to sign the arbitration agreement, or was tricked into it on due influence, and so on and so forth. Irregular constitution. The arbitral tribunal was not constituted the way the parties wanted it to be constituted. For instance, the parties wanted independent and impartial arbitrators, but one of them was not. And this was raised during the arbitration, and for whatever reason, the arbitrator stayed. Or the arbitral tribunal was irregularly constituted in the sense that the arbitrators did not have did not fulfill the requirements that the parties had chosen. The parties may, for instance, say, we want an arbitrator who is an engineer and who specializes in construction disputes. And then you get an arbitrator who is a lawyer. You object to that, but for whatever reason, the arbitrator stays. You can seek annulment of the arbitral tribunal on that basis. Breach of due process. The parties agreed that there would be witnesses and so on and so forth, and the arbitrators decided, I'm going to hear your witness, but not yours. That's unequal treatment. Or I'm going to hear arguments by both of you, but I'm not going to allow you to respond to all of the arguments of the other party. That's a breach of the right to rebut your opponent's case. And so on and so forth. Issues of jurisdiction. There was a valid arbitration, that's not technically true, but anyway, there was a valid arbitration agreement, but it did not cover the disputes at hand. There was an arbitration agreement for all disputes arising out of this contract, which points to contractual disputes arising out of the contract, but now we have a tort dispute. In the same case, we have a dispute which does not arise out of the contract, but which involves the same two parties. It's not covered by the arbitration agreements. There's a problem of jurisdiction of the arbitral tribunal over that non-contractual dispute. If you don't get the details of this, it doesn't matter. If you do get them, so much the better. But just remember these main grounds for annulment. Arbitrability. A dispute was not arbitrable under the applicable law, the law of the seat. Should not have been allowed to go to arbitration. An arbitrator decided that two people divorced in an arbitration, in the 99% of countries in which this is not allowed. You can seek annulment of that arbitral award because the subject matter is one of a kind that cannot go to arbitration. Public policy, either the procedure breached public policy, that's procedural public policy, or the outcome breached public policy, which is substantive public policy. Procedural public policy, in Switzerland, arbitral awards were annulled in the entire history of Switzerland, annulled once for breach of substantive public policy, and once for breach of procedural public policy, which is a way to say annulments, because an award is against public policy, are extremely unlikely to be successful. The breach of procedural public policy is that the arbitrators disregarded res judicata. There had been a prior arbitral award on a given matter, then there was a second arbitration with a second arbitral award, and the party losing the second arbitral award said, but you can't do that, you can't adjudicate the same case twice. That is a breach of res judicata. And the Swiss Federal Tribunal said, true, and they annulled the second arbitral award. The only time in which there was a breach of substantive public policy was a football player who left his club to join another. He had to pay a fine. It was a few 100,000 euros, I think. The seat was in Switzerland, but long story short, I think it was a French or English football player, whatever. The football player had to pay a large fine, and because he breached the contract. He could not pay that fine. It was too large a sum for him, and FIFA said, then you can't play. You'll be forbidden to play football for the rest of your career until you pay the fine. This went to arbitration. The arbitral tribunal confirms the penalty, that's the the sanction, that the player had to pay this, and the Swiss Federal Tribunal said that finding of the arbitral tribunal is against public policy. You cannot prevent a person from exercising his or her livelihood because the person cannot pay a fine. So the clause in the contract was problematic, and the clause was confirmed by the arbitral tribunal, and that was against substantive public policy. Perhaps the last point is the most important one, no review on the merits. An arbitral award cannot be annulled, appealed, quashed because there was a mistake with regard to the law applicable to the merits. Which means what? Which means that you may have an arbitration with a fantastic procedure, because if the procedure is not fantastic, it's going to be annulled, and it leads to an outcome which is arbitrary, but not against public policy, which is massively legal wrong, which does not make any sense, legally speaking, which applies, say, Swiss contract law in a way which would make a student fail the exam. What can you do? Absolutely nothing. And that does happen in practice. Not all the time, of course, but from time to time, you see arbitral awards which are catastrophically bad, following a good procedure, but the award is catastrophically bad, and there's nothing you can do about it. Okay, because there's no review on the merits. So there are a number of arbitrary arbitral awards out there which live on, which no one can do anything about. The one exception is English law. If you have an arbitration seated somewhere in England or Wales, then English Arbitration Act applies, and under English law you can appeal on a point of law. It doesn't succeed very often. It is used mostly for arbitrations where the arbitrators are not lawyers, and the parties say, if we entrust this case to engineers, for construction disputes, this happens quite often, for shipping disputes, maritime disputes. For these disputes, you have technicians, engineers, and people like that. The parties say, we'd like to have some supervision by the courts that they get the law more or less right, which is why they opt into, or rather don't opt out of, this possibility to have an award reviewed on the merits. Here are a few more examples. I'll let you read them. I gave you a few examples early on. I'll skip that. That just explains what I had in mind. This is perhaps more important. Some statistics. If you, because you're talking about finality, you get an arbitral award, you lose the arbitration. How likely is it that you can get it annulled? We've seen the grounds in which you can seek annulment. Statistically, how likely is it that you will be able to have it annulled? Less than 10% of the cases, of those cases where there has been an attempt, of course, there are no clear statistics about how many attempts there are to challenge arbitral awards out of all arbitral awards, but of those that are challenged, 7.53% are eventually annulled. Almost half of them in Switzerland are due to sports arbitrations, which tells you something about how sensitive, how problematic sports arbitration has become. It is a core aspect of the legal architecture of the International Olympic Committee. It's a core architecture of the legal, part of the legal architecture of the Olympic Games. It does create a number of legal problems, and quite often one of the parties, more often the athlete than the sports federation, is unhappy about the result and seeks annulment. This is just the detail. These are the details of the 5 main grounds for annulment under Swiss law and how successful they each are. You see, ordre public. In this wasn't produced by me, but anyway, this is public policy. 2 cases out of 194 attempts succeeded. It's less than 1%. And otherwise, it's mostly the right to be heard, which is attempted as a way to seek annulment. Jurisdiction is proportionally the most successful one. And then you have a bit of ultra and infra petita, which is a matter of, it's some form of due process. Let's not get into that. And constitution of the arbitral tribunal very rarely succeeds. So constitution of the arbitral tribunal would include things like a partial, not impartial, dependent, not independent arbitrator. Very rarely that this is a successful ground of annulment. Then, still speaking of finality, you can exclude under Swiss law, under French law, and under, I think, Singaporean law, you can exclude all annulment possibilities, which means that you get an award and there's nothing you can do about it. If the procedure was a catastrophe, if the outcome was a catastrophe, there's nothing you can do about it at all. I had to tell you a short story. I still have friends, but it was a time in the past, who were involved in an arbitration about a construction project somewhere in Africa. And they were suing the other party because the other party was, I think, 3 years late in the construction of the building that they had asked to be built. There's an arbitration clause. They go to arbitration. The arbitrator on the first day says, parties, I'd like you to waive all annulment possibilities. The seat was in France, but so the system is the same as you have here. And my friend said, oh, the arbitrator asks us to do that. We don't want to antagonize the arbitrator on day one. So they said yes. And then the arbitrator went on to do really n'importe quoi, whatever with the procedure, not hearing the parties the way they should, cutting people short, and rendering an award in which he said, this is a construction project in Africa. In Africa, the law is not applied. So we're not going to apply the law here. We're going to consider that construction projects, they're finished whenever they're finished, and claim that you get nothing. My friends came to me and said, so what can we do with this crazy awards? Can we not do anything? And I said, well, no. You agreed to waive annulment possibilities. That's the end for you. That's a way for you to say, it's a way for me to tell you, if you're ever involved in an arbitration and the arbitrator asks you to waive annulment possibilities, which can be done at any point in time, say no. Keep pressure on the arbitrator that there's at least some control over what they do. Otherwise, they may go crazy. Recognition and enforcement, last part for today. Recognition and enforcement of arbitral awards, typically abroad. Within the same country, it's really easy, but abroad, it's maybe a bit trickier. What is recognition and enforcement? Recognition understands it as a shield to protect you against further legal action, against further court procedures, against further arbitrations. There was an arbitration in my case, there was an award. This is going to prevent the other party from suing me again in another country, for instance. Res judicata. Enforcement is a sword, by which I mean it's the way that it's how to get the assets of a recalcitrant party. You have a party, you win an arbitration, the other party says, go to hell, I'm not going to pay you anything. How can you get to their assets? How can you have the assets seized by having that award enforced? L'exécution en français. The main legal text for that is the New York Convention. We've discussed it in class 2, I think, briefly. Let me just expand on it a little bit. New York Convention 1958, full name, Convention on the Recognition and Enforcement of Foreign Arbitral Awards. The most important international legal text for arbitration, 172 member states, out of the world's slightly less than 200 states. All those in blue on the map, plus a few more because I didn't update the map. It's in the last, I should have, but I didn't. In the last 14 years, a number of additional countries have signed on to the convention. What does that mean? Almost all of the commercially active countries in the world are members of the New York Convention. The vast majority of them. What are the grounds on which you can prevent the enforcement or recognition of an arbitral award? So what the convention says is all member states of the convention, you have to recognize foreign arbitral awards unless the party opposing enforcement can prove that one of these grounds is applicable, is fulfilled. So you're going after the assets of the other party in another country because you're trying to enforce the arbitral award. That other party is going to say, no, you can't touch my assets here because the arbitration agreement was actually invalid. So the arbitration shouldn't have taken place anyway from day one. The arbitration should have been killed straight out of the gates. There were other jurisdictional issues. The dispute at hand was not covered by the arbitration agreement. Or the issue was one of a kind that is not arbitrable, that's a ground to refuse recognition and enforcement. I was not properly notified of the proceedings. I didn't know that there was an arbitration, put differently. The arbitral tribunal was not constituted properly. The arbitrators were partial and dependent, not impartial, not independent, or didn't fulfill the characteristics that we parties had agreed on. Or the award was annulled in the country of the seat. You have an arbitration, you move for annulment, the annulment is successful. The piece of paper still exists, of course. The piece of paper is not ripped apart, but it is legally invalid. What then if the party which had won the arbitration and lost the annulment procedure takes that piece of paper, goes to another country and says, here's an award, enforce it against the assets of the other party. The other party is going to say, wait a minute, no, you cannot do that because that award was in fact annulled in the country of the seat. Or a breach of public policy in the country of enforcement. If it is against the public policy of the country where you seek enforcement, it's not going to be recognized and enforced there. For instance, you have an arbitral award in the dispute arises out of a sales contract for alcoholic beverages. Okay, there's a dispute, someone didn't do something. It goes to arbitration, there's an award. The assets of the losing party are in Saudi Arabia, but in Saudi Arabia, the sale of contracts for the sale of alcohol are, let's assume, certainly was the case at one point in time, they are illegal. Not only are they illegal, it's against public policy there. The Saudi courts are going to say, your arbitration is all fine and good, but it won't have any effect here because here it is against public policy. You have examples on the slides. We have a quiz, Dimitris, today, no? Yeah. Should we? I'll leave you to go through the examples on the slides. There's not much more. I would just read them out to you. There's not much of a point. And we'll go through, we'll do the quiz. One last point on the award annulled, just because it's quirky, or possibly interesting. I hope I haven't mentioned these stories before. There were cases where a country said, the country of enforcement said, yes, the award was annulled, but we're going to recognize it and enforce it anyway. So what that means is that you have an arbitral award rendered in a country, it's annulled by the courts of that seat, which means that legally speaking, that award no longer exists. Okay? And still you have another country which says, we're going to enforce that award. Because the convention says, as the slide says, foreign arbitral awards may be refused and not they have to be refused recognition if these grounds are fulfilled. So why would these countries recognize and enforce an arbitral award rendered in another country if it has been annulled? What's the logic behind it? The two main cases where this happened, there were more, but the two are representative. One arbitration took place in Saudi Arabia. The seat was Saudi Arabia, and under Saudi law, women are not allowed to be arbitrators. There was an annulment procedure against the award rendered by such an arbitral tribunal. The court said, applying the law, the award is null and void. It is annulled because a woman can't be arbitrator in this country. Then the party which had won the arbitration and lost the annulment, came with the award to France and said, French courts, you cannot possibly refuse to recognize and enforce an arbitral award for the sole ground that one of the arbitrators was a woman. And the French court said, fair enough, and they enforced it. Second case, an arbitration seated in Russia, in Moscow. It was shown years later that the arbitrator had been bribed. And, the judge had been bribed. There was an arbitration, goes for annulment, the judges have been bribed, they annul the award. The party that won the arbitration and lost the annulment procedure goes to France and says, French courts, you cannot possibly not recognize an award which has been annulled for the sole reason that the judge was corrupt. And the French court said fair enough, and they recognized and enforced it. Okay. That's it from me. Oops. You have it here? Thank you. To what? You find it on the slides on Moodle, the QR code is shown, so you don't have to wait for me. It's...
To make it bigger.
No, it has to be, I have to move the window to... I have to move that window. How can I move that window? Yes, exactly. Yes. Huh? Oops. Yeah, I'll do it. Thank you. Thanks. So here's the QR code. Please do scan it. It's the same that you have on the slide. It's the same you have on the slides in on Moodle. And if you want, go through the questions. Okay, not many. Much better. Oh yeah, okay, I'll discuss it later. Thanks, Dimitris. Okay, here are the answers. Yeah, your answers. An arbitral award rendered by a tribunal seated in Switzerland can be annulled by the French courts. Seated in Switzerland, annulled by the French courts. 28% said, oops, that's wrong. No, it cannot. The seat of an arbitration determines the courts before which you can seek annulment. If the seat is in Switzerland, only the Swiss Federal Tribunal can annul such an arbitral award. Okay? Annulment only in the country of the seat. That's the sort of thing you need to know for the exam. Okay? By choosing the venue of their arbitration, by choosing the venue of their arbitration, the parties designate the place where the hearings will take place. Yes, the term venue means the place where the hearings are held. That's what the word venue means. The place where the hearings will take place ends the law of the seat. No, they don't choose the law of the seat. The venue is separate from the seat. Okay? The seat is the legal place where the arbitration takes place. The venue is where it actually takes place. They can happen to be the two, to be the same, but they don't have to be the same. So by choosing the venue, you're definitely not choosing the seats anywhere. Okay? It may be that the seat is in Geneva and you choose the venue in Paris, to put the venue in Paris. That does not change anything about the seat. The seat remains in Geneva. By choosing the venue of the arbitration, the parties designate an arbitration institution under the rules of which the arbitration will be conducted. No, the choice of the venue has nothing to do with the institution under whose rules the arbitration is going to be conducted. These are separate notions: the venue, the seat, and the choice of the arbitration institution. You can have you can choose the ICC, French arbitration institution. You can have the seat in Geneva, and you can have the venue in London. Okay? These are three independent concepts and aspects of an arbitration. Well, all of the above obviously is wrong as well. Where's my... So I'm trying to scroll down. Perhaps that works. Yeah. The enforcement of foreign arbitral awards depends on their possible annulment. Yes, if it is annulled, if an award is annulled, that is going to affect its enforcement. I mentioned a few cases where it did not, but that's really, truly exceptional. It certainly makes it a whole lot less likely that an award is going to be enforced if it has been annulled. So it does affect it. Arbitrations are by default confidential. Yes. Yes, they are. I'm a bit concerned that a quart of you said no when I think I had a slide that specifically said arbitrations are by default confidential. But okay. These are the sort of things you'll have in the exam. Not terribly complicated, doesn't require a lot of knowledge, but the core concepts have to be clear. Okay, I hope that wasn't too shocking. Thank you very much, have a good week, and I'll see you next week. Thank you. Thank you very much. Conceptually, there's a clear distinction between the notion of ridiculous you apply to performance of contracts and the one you apply to the recognition of it does not mean that it is out of the hands of states to decide what is part of that state. And then there are some countries like China does not have the basic it's not a breach of any treaty. It's against the principles of the arbitration here in the West. But for them, and in a number of Arab countries, that distinction is much less clearly statement.
Concerning the example you gave on the sales under which category or key aspect you mentioned, what was the
International public policy. Just public policy, it's the international dimension of public policy. That's the language it's
because that was the arbitration.
No, that's the case of enforcement.
That's the case of enforcement. I was just distracted at that moment.
If you think enforcement, it's the notion of public policy is enforcement. Then I more understand, you simply cannot have it enforced in Saudi Arabia before you have it enforced.
It's the understanding, and there's nothing is rendered as fine, and you just go there, seek enforcement, and they confuse it because they say we started mention everything, but how domestic alcohol policies in Saudi Arabia, they refer to that under international public policy.
The notion of international public policy didn't want to expand it. It's a complicated is each country's own understanding, which they decide arbitrarily, of what is so fundamental for them that they are going to apply it even to international situations. It's their own decision. Most EU member
They're
states
just prioritizing it over their generally
yes,
accepted.
the new approach allows public policy, but what they put into the context of what is public policy for them is for them to decide. And some countries like China don't make a difference between domestic and international policy. Other examples are most EU countries would say there's arbitration awards which go against competition law are legislative. They don't implement it.
Such a high value in the
It's in most EU countries, I think, in many EU countries, the competition is arbitrary. So they say this has to be is that some the US was how can they do that? That's impossible. So what is shocking for us when we say alcohol in Saudi Arabia is something like the equivalent of for us competition is so sacrosanct but for other countries
it's cultural.
it's cultural. Yes.
Perfect. Thanks a lot, Margaret.
On choisit le droit applicable, on ne choisit pas forcément le droit D'accord. Et donc, le tribunal arbitral
Je vous écoute, mais je dois rendre parce qu'après j'ai un autre cours.
a lieu en Suisse. Ce que vous avez dit, c'est que les parties elles peuvent totalement déroger aux règles tant qu'elles se consentent. Donc, ma question, c'est est-ce que dans ce cas-là, il n'y a pas une violation de l'engagement excessif selon le droit suisse
Non. Bonne question, madame.
Ça fait pas non plus en partie des policiers.
Oh yes, of course. Sorry, I don't have my diary on my. Of course. Thanks so much for today.
Ça rentre pas dans les. Parce que la FDP, elle prévoit quand même l'application de certaines normes de droit suisse quand les droits refus.
La LDP pour l'arbitrage, c'est vraiment le chapitre 12, c'est pour ça. Une violation, par exemple, d'une loi de police qui est prévue par la LDP, de l'application immédiate, etc. Potentiellement, ce n'est pas forcément une contravention à l'ordre public. Il faut qu'il
C'est la violation d'une disposition dans la LDP.
C'est le chapitre 12 de la LDP sur l'arbitrage va vous donner, je sais pas va vous donner une liste exhaustive des raisons de recours, des motifs. Et ne figure pas dans cette liste-là la violation des lois d'application immédiate. Et donc d'aller chercher ailleurs dans le droit suisse, et dire ah mais c'est contraire aux engagements excessifs, etc. Si c'est pas dans la. C'est vrai. si l'engagement, si le tribunal considère que l'engagement accessible est contraire à l'ordre public, donc précis l'ordre public international, dans ce cas, oui, mais
Je crois pas, non.